Last week, we learned about how the education system was unequal from an economic perspective. Now we're turning our attention to examining how the social organization of society and our education system reproduces racial disparities in education. We're beginning this portion of the unit by reading a chapter from Lipsitz's book, The Posessive Investment of Whiteness. I asked you to only read certain sections of this chapter, recognizing that there's limited time in the summer session, but I am going to talk to you about a section here that I'm not requiring you to read because I think it helps you to appreciate even more the content of the section that you're required to read. So given civil rights laws like the Civil Rights Act of 1964 and the Voting Rights Act of 1965, outlawing overtly discriminatory practices passed almost 60 years ago. Most people believe that the problems facing communities of color are no longer due to racial discrimination because of the amount of time that's passed. Now people see that the problems in communities of color, they see those problems in communities of color as a result of their cultural practices. They blame the characteristics of the group themselves as the root cause of their problem. This is often called victim blaming, as that perspective ignores the structural factors that produce those problems. A blame the victim approach deflects attention away from the way that the structures of our society or of our social institutions reproduces the inequalities that adversely affect people's life chances. Lipsitz asserts that the evidence of the record shows that civil rights laws and Supreme Court decisions that opened the channels of mobility actually intensified white people's possessive investment in their whiteness. These laws and decisions caused them to organize and mobilize their social, economic, and political resources to preserve the privileges they had prior to the court decisions and the laws that were passed. Lipsitz states that over the last 50 years and at every stage, white people responded to these civil rights laws in the country with political actions that he characterized as resistance, refusal, and renegotiation. And in this chapter, he discusses three areas: housing, school desegregation, and fair hiring practices that demonstrate that. While I'm only requiring you to read the intro and the conclusion and the section on education, I'm going to talk about housing because the housing policy produces the segregated schools that then needed to be desegregated. But I'll just address this briefly. Again, you don't have to read that section, but I think it's really helpful. Prior to the 1930s across the nation, local communities had developed their own race-based housing zones that determined where people of color could live and then where white people could live. This was particularly true for African Americans who experienced de jure discrimination, which is discrimination by law. You had white-only neighborhoods and black-only neighborhoods and Asian-only neighborhoods when there were large enough population sizes. So race-based zoning was a standard practice at all local levels across the country, though the language that defined those areas was not standardized across the country. The language and the practices were localized. But when the Great Depression began, things really changed. Our elected officials were trying to come up with ways to jumpstart the economy. They decided to target housing because housing is one of those industries that connects to all types of labor. You have skilled professional labor like engineers and architects. You have skilled working class individuals that would include like plumbers and electricians and carpenters and welders. You would need to design the roads and water and electrical infrastructure, build pipelines and roadways. You would need semi-skilled workers and artisans, painters, drywallers, roofers, ditch diggers, and cleanup crews. So jumpstarting the housing industry would have ripple effects across the economy because you need to build schools and parks and grocery stores and buy cars. And again, the ripple effect will go on and on and on. And they saw this as having a positive impact on the country. Now, public officials also wound up rewriting housing policy and passed the National Housing Act of 1934. This is the 1930s, right? In the middle of the Jim Crow era, these housing policies made home ownership affordable and accessible even to low-income white people. In fact, low-income white people actually lived in public housing But because of this National Housing Act, they could actually pay less for a mortgage than they had to pay rent for a public housing apartment. So they left those apartments and bought homes. This new housing program was not available to people of color, especially to Black individuals. In fact, around 98% of all home loans between 1934 and 1968 went to white Americans. What's more, if people and businesses wanted access to those programs, they had to have what were called restrictive covenant clauses in their contracts. And that clause basically said that these homes could only be bought by white people and could not be sold to Black people, or could only be sold to white people if the original families wished to sell their homes. So for 30 years, non-Hispanic whites were given an opportunity to become homeowners and build wealth for themselves and their families, and people of color were not. This National Housing Act, in essence, helped to create the white suburbs. The federal government provided the standard language for the restrictive covenant clauses. There's so much more here that's beyond the focus of this course, but I want you to think about how the power of the federal government was used to, one, create wealth and homeownership opportunities for white Americans, but two, also changed the urban landscape so that you had these basically white-only suburbs and white-only new subdivisions that then had contracts that basically guaranteed that the next generation of homeowners would just be white. And you have to remember that the rewriting of housing policy basically created the 20-year mortgage. And so we're cementing these racially homogeneous neighborhoods in a way that hadn't existed before. And so when people say, oh, it just happened, people like to live by other people who are like them. No, this housing policy helped to create white-only neighborhoods, but then also perpetuate those white-only neighborhoods. And this National Housing Act, right, then had generational consequences for families and children. And I'm just going to show you the Austin map, and this should look familiar because we talked about it in the Berliner lecture, I believe. So here are the formal boundaries that were defined by the Homeowners Loan Corporation. These areas that are red were the hazardous areas, which were, you'll see that red line. Basically, it means that only Black people could live in these areas. The blue shade was deemed like the best or most desirable areas. White people lived there. And then the yellow areas were the declining areas, which included where Hispanics lived, but where they were also concerned that you would have encroachment by Black families. And again, this one is the one that should look familiar. These are the population dots for the different races in Austin in 2020, nearly 80 years later. This chart, again, you've seen it before. The teal color or the blue-gray color is now where the Hispanic or Latino population is. The bright blue right here is Asian alone. And then the tan colors are where the non-Hispanic white alone population lives. And then you can see these kind of traces of bright yellow where the African-American alone are. And what I did is I put the two maps side by side here. You can still see traces of those racialized areas from the 1930s. Recently, Austin has been going through gentrification, where affluent people are moving into the areas that historically have been for communities of color, or where people of color lived, and those people are now moving away from the center of the city out into the peripheries and in the outskirts of Austin. And when you have racially segregated communities, your education system, because it is a locally organized, or because the education system uses neighborhood schools, you wind up getting racially segregated schools because you have racially segregated neighborhoods. And these segregated schools created separate and unequal opportunities for children, again, with children of color, specifically Black children, not having nearly the same quality of access to resources, educational opportunities as their white counterparts. And you probably learned about the Brown v. Board Supreme Court decision of 1954 that declared that separate segregated schools were inherently unequal. This ruling outlawed dual education systems, but the decision only ruled out segregation by law. That's what that de jure segregation means. The problem with the decision was that it included the phrase "with all deliberate speed," and in other Supreme Court rulings, typically the party that was ruled against only had 20 business days or 1 month to comply with the Supreme Court decision. But with the Brown v. Board, Supreme Court justices ordered that the states and the desegregation happen with all deliberate speed. And to be fair, right, some judges were concerned that that language specifically would allow for the school districts to drag their feet and not make the necessary changes. There was lots of back and forth among the Supreme Court judges, and ultimately those concerned judges, the ones who were concerned that the school districts would use this phrase to drag their feet, were right, because in 1964, Justice Black had to tell the parties involved in the case that the time for deliberation was up, because less than 2% of the schools had actually began desegregation plans. Now, that's 10 years after the initial ruling. That's almost a whole generation of children who should have been able to go to integrated schools, but who wound up not going to integrated schools. They were robbed, essentially. And what's important is that this was an active resistance, right, to deliberate for 10 years. And it's important for us to remember that this resistance wasn't just in the South. It was in the North too. And the evaluation of remedies for integration actually didn't even begin in concert until 1968. So think about that, what that means for children. They were denied access to quality education, and for themselves, but also for their children's children, because the denial of access to quality education also means a denial of access to quality jobs and benefits, and all the advantages that flow from those good jobs and benefits. And this is even more problematic when you have to acknowledge that school districts didn't actually get financial assistance with their integration plans until 14 years after the decision. The Emergency School Aid Act of 1972 was designed to help with the desegregation of schools, because one of the complaints that the school districts were making that were required to desegregate was that the busing that needed to happen to integrate the schools was extremely expensive. And so the federal government passed this act in order to help subsidize that. Again, because you had segregated schools, you had segregated neighborhoods, you were literally going to have to drive kids across neighborhoods so that you could integrate the schools. It wasn't just going to be redrawing boundaries and then getting this magic integration. And so if we think about, that 1971, we're looking at, nearly 18 years after Brown v. Board, before you really do see the power of the state, the political machinery, right, in providing subsidies to school districts to help with the integration process. And I want you to remember what we've learned from our previous lectures. There are real cumulative long-term consequences related to lost opportunities when students are denied quality education. And so for nearly 18 years, we saw delay and denial of educational opportunities. Okay, and I think it's worth noting that this Supreme Court decision, really only related to Black and white children. And in a community like ours, and if you've taken any of my classes before, I've talked about this. Mexican American children were not specifically addressed in this Supreme Court decision. So what we actually see in communities like ours in Corpus, we see Mexican children being used as pawns in desegregation plans to help white people avoid having to go to school with Black children. So Corpus Christi Independent School District actually said, hey, look, Mexican American children are technically white children. So Mexican American children can go to school with Black children, and that will satisfy the integration of Blacks and whites. And that allowed the non-Hispanic white children from exempted them from having to integrate after the Brown v. Board decision. And it wasn't until 1970 that the Supreme Court basically said that the protections outlawed in Brown v. Board were extended to Mexican American children. So that's 1970, so this delay and denial of educational opportunities also then denies those children future economic opportunities when they were grown-ups. And then that denial of the economic opportunities extends to their children's educational opportunities, because these families that didn't have the educational opportunities didn't also have opportunities for or better economic opportunities. Again, there's these generational consequences, and I cannot emphasize this enough. And the picture that you're seeing right here is a meeting that was held we used to have this place called the Harbor Coliseum. And once the decision came down that the protections in Brown v. Board were extended to Mexican American children, and CCISD was mandated to integrate their schools, that they needed to have an integrated education. Up until this point, we had one system for non-Hispanic white students, and then we had one system for Black and Hispanic students. And so when it became clear that there was going to need to be an integration plan, this group called Concerned Neighbors held a meeting at the Memorial Coliseum, and we're trying to encourage white families, and then later families of color, to boycott the school district and keep their children home. And so, I mean, this is a lot of people in 1970. And it wasn't until 1975 that the courts approved the integration plan that was proposed by CCISD. So again, if we think about it in the context of the 1954 Brown v. Board decision, guys, we're looking at more than 20 years before Mexican children had those protections. And that's generations of lost opportunity. And really, the parents care about the quality of education that their kids are receiving. And so those integration plans really forced parents to have to face and acknowledge how disparate and unequal education was based on, the racial demographics of the school. Now, and those weren't the only times that we saw non-Hispanic white individuals resisting people of color having access to quality educational resources. There were families that in San Antonio that sued the San Antonio Independent School District because of the way that budgets for school districts were created. By relying on property taxes, they argued that this created substantial differences in the quality of resources by school district. School districts with high property values, which were going to be white school districts, would have more resources than poor ones, producing huge disparities in the budgets from the various school districts in the state. And again, I've already talked about this, but what I wanted you to be cognizant of was that these practices were challenged as creating unequal educational opportunities. Like, people acknowledged that these were problematic and tried to use, the courts to create more just and equitable structures for our education system. I mean, again, this is the early 1970s, so nearly 50 years ago, right? And families attending poor school districts were fighting to get more equitable ways to fund public schools, because the amount of money a school district has, recall from like Hochschild's work, those resources influence the quality of resources and educational opportunities. But ultimately, the Supreme Court ruled against these families, saying that, now people had the freedom to live where they wanted and could choose a school district to live in that was more in line with what, their values were regarding educational opportunities for their kids. So basically, like, if you're dissatisfied with the school district's resources that you live in, just move to another school district. But, the Supreme Court blatantly ignored the fact that lower income families don't have the economic capacity to relocate into neighborhoods that are into those neighborhoods with the best resourced school districts. It's just not possible given the unequal opportunities that existed in our society, connected to the Jim Crow practices that were in place from the 1870s, all the way through the late 1960s. And not only that, in the Milliken versus Bradley case in 1974, families who didn't want to integrate actually sued for clarification about where integration had to take place. Because in some cities, what you saw or what you had were multiple school districts. And so the question was, do you need to integrate schools across districts within, say, a municipality, or just within a single school district? Ultimately, the Supreme Court said that you only had to integrate within the school districts. And this decision really supported the white flight that would occur out of those central school districts. Families not wanting to integrate could move outside the school districts that required integration. We saw that across the country. Here in Corpus, in the Corpus Christi Independent School District, we saw families basically move to neighborhoods that were zoned for Flower Bluff ISD or Calallen ISD to avoid having to integrate with children of color. And so again, there's this evidence of prolonging and promoting unequal educational opportunities based on race. And then, in 1981, after Reagan was elected, he put an end to providing resources to school districts to help them with the cost of desegregation, offloading the burden back onto those school districts. So, there was really never a strong commitment to providing all children, especially children of color, access to high quality educational opportunities. Families of color, poor families, really had to fight to try to get more equitable resources. And what we repeatedly saw was not just, white people in the communities mobilizing and using their resources to resist that, I guess, policies that would create more equitable opportunity, but we also saw the Supreme Court repeatedly make decisions that ruled in favor of non-Hispanic white individuals who already had, a near monopoly on quality educational resources at the K through 12 level. But we also see evidence of this at the higher education level. The chapter discusses the medical school program in California and how non-Hispanic white individuals mobilize their resources to undermine minority students' opportunity to participate in a special medical program. Please pay attention to that. I'm not going to talk about it. I'm already talking way too much. And then because I want to talk a little bit about this too, I included two decisions, Hopwood v. Texas in 1996 and Greta versus Bollinger in 2003. These are other cases that challenged minorities getting access to law programs. Here, there were claims of reverse racism that took precedent over considering the fact that minority students historically have not had the same kind of access to quality educational opportunities as their non-Hispanic white peers. This is all to show that the resistance to opening previously closed off channels of mobility for students of color has been ongoing. These oftentimes, like Supreme Court decisions that took place, like Brown v. Board, gets celebrated as an end to an era. And what we see, if you pay attention to the behaviors after the fact, you see delay, denial, right? What Lipsitz called resistance, refusal, and renegotiation, where non-Hispanic whites, quite frankly, are mobilizing their resources to limit the equal opportunities, or limit more equality and opportunities for education. And that's important because for a lot of us, right, we're okay with the inequality because we think of the education system as being a place where students have an opportunity to demonstrate their capacity and to achieve based on their efforts and their talents, and to not be limited by their backgrounds. But what we see in the Lipsitz piece is that the things that they don't have control over, their racial classification, their access to resources, really does limit their educational opportunities. So historically, what happened is that these policies that were in place that denied people of color access to good quality resources often made no direct mention of race, but the remedies they sought usually contain language related to racial classifications or racial categories. So, for example, in Corpus, there in the decision for the Cisneros case that extended the protections of Brown v. Board to Mexican-American children, the judge found that there was a dual education system, one for whites and one for students of color, specifically Black and Mexican-American children, and ultimately ruled that no school should have more than 75% of one racial group within that school. So, that discussion and acknowledgement of racial categories or classifications would then be used by white people to say that those who wanted access to better resources were the ones that were being racist, rather than acknowledge how the social organization of society created qualitatively different life chances for people of different races. The Supreme Court and political leaders who were disproportionately non-Hispanic white often sided with other non-Hispanic white people who benefited from the systemic inequalities that channeled better resources and opportunities to white people, often at Black people's expense, as well as other people of color. So for minorities, they often face what's called inferential racism, a type of racism that's structured into the very organization of our society and that harms the life chances of people of color. The differences in life chances for the differences in the differences in life chances for different races in our country is not just a product of somebody sneering and snarling and shouting racial slurs and being individually racist toward a minority, but it's in the creation of the segregated neighborhoods and the segregated schools and the segregated facilities and the segregated amenities and the white supremacist ideology that where many non-Hispanic white people feel and behave and act as though they are the only ones who should be entitled to quality resources, and who resist the spending of capital to increase minority populations' access to those desirable resources. He notes that people can be outraged by overtly individual racist acts, by racist individuals that use racial slurs or act blatantly racist, but he wants you all to think about, and for us to think about, how these same individuals that would clutch their pearls and say that, you know, it's so bad to be racist, will also resist investing in programs and policies that could lead to people of color having, you know, more access or similar access to resources and opportunities that have been and continue to be only extended to white people. And so I know that this can be a challenging topic, but you know, I think it's an important one because it helps us to see that the patterns that we see in our broader society aren't just a byproduct of the individual choices that we as people make in the moment or in our specific lifetime, but they're structured into our social institutions. Okay, so I'm going to stop right there, and we'll continue with the next reading.